Hi, very good morning. This is a Supreme Court judgment, interesting judgment, commercial litigation. Levitate Mobile Tech Private Limited versus Standard Chartered Bank. Issue before the court was in commercial litigation, can a company produce additional documents by adopting a piecemeal approach? That was the issue. LMT, that is Levitate Mobile Tech Private Limited, and Standard Chartered Bank, SCB, they entered into a professional service agreement for development of a particular app. The app was launched across the Android and iOS system. Suddenly, for some reason, SCB asked LMT to take down the app. Then LMT filed a suit alleging losses. LMT claimed a few crores of rupees for their services and they also claimed interest. A civil suit was filed in the Delhi High Court. Parties completed their pleadings, issues were framed. LMT filed an application to file additional documents after filing the suit. That was allowed by the Delhi High Court. Then, after the Commercial Courts Act got introduced in 2018, so the case was renumbered in 2018. Later on, the evidence of one of the witnesses was examined and completed. After that, LMT filed another application to bring additional documents and recall the witness for examination. The reason for the delay was stated to be one, large quantum of emails were there. Then two, difficulty in keeping track. So because of the volume, then voluminous records. For specific government during cross examination, that was there, which we did not expect. Five, LMT said that it is only substituting the existing case, not bringing out a new case. What are the submission for bringing additional documents on record? The court rejected the application applying reasonable cost test. The Delhi High Court said no, your second application is rejected. They filed an appeal to the Supreme Court. Supreme Court relied on its judgment in Sudhir Kumar versus Vinay Kumar, wherein it was held the plaintiff is obliged to file all the documents in its possession along with the plaintiff. Of course, it can seek leave to file and rely on additional documents if so desired within 30 days of filing the suit, and that too after making out a reasonable cause for non disclosure. Reasonable cause and justification explaining the subsequent discovery thereof needs to be well established. You cannot be simply say, no, no, I have reasonable cause. You have to establish that. And it relied, the Supreme Court relied on another judgment of Bose brothers, wherein it was held sufficient cause is not elastic enough to cover long delays beyond the period provided in provision itself. Law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when statute so prescribes. The law is hard, but it is a law. In case a party is found to be negligent or for want of bona fides or not acted diligently or remained inactive, there cannot be a justified ground to condone the delay. That was said in the Bose Brothers Engineers case. Supreme Court noted that the suit was filed in 2015 and still it is at the stage of plaintiff evidence. That is 2026. Issues were framed in 2016. Examination of plaintiff witness was in 2023. The ground for filing the second application was certain new facts emerged during cross examination. Supreme Court said it is well established that plaintiff when leading evidence is expected to not only produce all documents but also properly anticipate questions that may be put to the witness. So it is not enough you produce the documents whatever you feel like. You must also anticipate the questions that may come from the other side, and you must produce documents in anticipation of those questions. What cannot be countenance in a countenance is a stop and go on a piecemeal approach. The submission of voluminous evidence, Supreme Court said, it was also not inspiring, because they said, no, no, we had a lot of email communications, voluminous records. Supreme Court said it is not inspiring. Evidence, however voluminous, cannot water down the statutory intent, because intent is it should be finished within a short period to improve the ease of business. All documents were in possession at the time of filing the complaint, so you should have produced it. If permitted, court would be condoning a piecemeal approach, which is against the object of Commercial Courts Act. The court noted that the suit was filed in 2015. In 2026, the plaintiff evidence is going on. Supreme Court said that even a snail may question the speed at which the trial is proceeding. So, Supreme Court noted that the additional documents were allowed to be produced for the first time. When you produced it in the first time, Delhi High Court allowed. Now, again, you are seeking to produce additional documents. That is it. This is the second time. Reasons in the first application and the reasons given in the second application are one and the same. Hence, Supreme Court said there is no interference in the order of the Delhi High Court rejecting your second application. The argument that the strict nature of Commercial Courts Act cannot be applied to the present case, that was also dismissed, because the case was filed before the introduction of Commercial Courts Act 2015. Supreme Court dismissed the appeal, stating that there is no case for interference. Comments, I have a few comments. One is proceedings invariably in all courts, within quotation, all courts, are moving in snail space only. That is a fact of life. Every court, it is moving in a snail space. According to me, AI technology, maybe it can be employed. It gives a summary of even a few hundred pages of writ petition. You just put a AI summary, it gives it in 1 or 2 pages. What is there? After that, you can go through it. The judge, it becomes easy for a judge, and he can easily question, make the questions, make up his mind before coming to the court. Or the students, brilliant students are there. Nowadays, the students are very well equipped in this AI technology. So instead of going and sitting in the lecture hall, I'm not saying lecture hall is not important, but they can be usefully employed by the courts without money. So they can learn a lot, and they may help the court in making it fast. Then three, each advocate or senior counsel, they take their sweet time when they are arguing in the court. According to me, every application, everything must contain the first page. How much time I will require to argue. If it is 10 minutes, 15 minutes, then those cases must be taken up immediately and finished. If somebody says 2 hours, okay, you give him 2 hours, but it should be, because the court can dispose of the small cases immediately, is my view, so that that will become easier. And each judge should be given a minimum target. How many cases you have disposed of this month? Every month. So minimum, if I say in a day, even if it is 5 cases, 150 cases can be disposed of in a day. Even AI technology here can be used. The While the argument itself is going on, it can record, and then uh, uh, the order can be immediately finished. Then arbitration. I think all civil cases must be compulsorily sent to arbitration to free the courts. So many civil cases. So arbitrated, there are many retired judges, many brilliant advocates who wanted to become judges, they have not become judges. They can be made as arbitrators, so that they can finish the matters within 6 months. Many civil cases, opportunity should not be given, because they want to delay the proceedings. Compulsory arbitration, go to arbitration. I can say much more, but I should have a time limit for completing my videos also. Hence, I am stopping here. Thank you very much. Have a great and wonderful day.